Okay, Deregulation Act. Everybody should know about the Deregulation Act. In short, at the start of tenancies, you now have to be able to prove that you have served on your tenant the EPC, the gas safety certificate, the most current how to rent guide, and, where applicable, a copy of the licence. That one is key. So not only HMO landlords, selectively licensed areas, they must have had a copy of the licence. And you must also have registered the deposit within 30 days, issued to the tenant the prescribed information in relation to where the deposit is held, and also the terms or the leaflet provided by that scheme. So for TDS, it's a leaflet. For DPS, it's terms. If you cannot prove that you have carried out all of those things, your Section 21 notice will be null and void, and you will not gain possession. There was also major changes in terms of the lifespan of the Section 21 notice. Section 21 notice now only has a lifespan of 6 months from the date of service. Not the date of expiry, the date of service. So once your notice has expired, in theory, you only have 4 months to act and get that into court. If you don't do it in that timescale, you'll need to reserve. Also, you cannot serve a Section 21 notice within the first 4 months of the initial fixed-term tenancy. So if you do a 6-month tenancy agreement, you cannot serve notice until 4 months have passed. If you then renew that tenancy into a further fixed term, you can serve notice at any time. You don't have to wait for the 4 months every time. Okay? There was a new form that was brought out for all tenancies that started from the 1st of October 2015. And we then had to use Section 21 Notice Form 6A. But we were still able, for tenancies that started prior to this date, use the old Section 21 notices, which was 4A and 1B, I think. So any notice that was served after the 1st of October 2015 had to use the Form 6A and had to comply with the with all of the documents that we had to serve. And the licence is obviously relative, and the restrictions on serving the notice as well. One of the key things to bear in mind with the new Form 6A is retaliatory eviction. If your tenant has successfully gone to the council, obtained a schedule of works that has been sent to you, and then the council has subsequently issued you with what's called an improvement notice. Anybody ever been issued one of those? All good landlords, that's good. If it gets to that stage, you then cannot serve notice on your tenant for 6 months until after that notice has expired and the work has been carried out. So please, in terms of maintenance, bear this in mind, because Section 21, again, like I said earlier, is very relevant on maintenance. So there were Section 21 changes on the 1st of October this year. And quite simply, the change was Section 21, 1B and 4A, or whichever way it was, are now gone. They no longer exist. They cannot be used on any tenancy any longer. And you have to use the notice Form 6A. What that now means is that you have to comply with what's written on that notice. Has anybody read the Section 21 6A? You lot are naughty. You must read it, because it clearly states, and if it clearly states on there, it's clearly telling the tenant, if your landlord has not done X, has not done Y, has not done Z, this notice is void, please ignore it, basically. It tells them everything you should have done before serving that notice. Told you I was going to give you live examples because I think they're really relevant and they're easy for you to put into context. And we had a case recently that unfortunately was thrown out of court. And the reason for this was because the documents were served on the tenant. It was a pre-2015 tenancy. We used Form 6A, but we served the documents that we were required to serve in the same envelope as the Section 21. The requirement is that they have the documents prior to the service of notice, and therefore it didn't comply. So if you are now serving notice on a pre-2015 tenancy where they haven't had all of the documents that they legally need, because you didn't have to do it back then, 2 days before you're serving notice, serve all of the documents and be able to evidence that you've done so. Now, what we're doing at the moment, when a tenant moves in, we get them to sign to say that they've had all of these. If you're serving them mid-tenancy, you're not going to get that signature, so make sure you've got some other form of evidence, certificate of service, email, something to show that it has been served on them. And when doing email, do not use links, because links are not deemed as served. You can attach PDFs, but you can't attach a link. And if you are going to serve any form of notice or any documents on your tenant via email only, you must have their consent to do so in terms of the email address where they want them sending. Because what the tenant can say is, I didn't receive that and I didn't give you permission to serve on me at that email address. So again, bear that in mind. We do email and post just as a back. Yeah, so any questions on that, guys? Basically, from 1st of October 2018, there's only one Section 21 notice you can use now. Please make sure that you've served all of the documents and make sure that everything is in order. We also had a case recently where we needed to serve notice, but the tenancy started in 2006, and therefore there was no EPC because there wasn't a requirement to have an EPC in 2006, but landlord had to get one before he could serve notice. Bear all of these things in mind. Bear in mind when you serve notice, because EPCs are now expiring, because we're after 10 years, 2007 they came in, it has to be a valid EPC to gain possession of your property. So bear that in mind. Any questions on Section 21? Wonderful.